Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome back to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. Our producer is Jody Mayer Piazza. It's been 50 years since political campaigns became highly regulated. It all started with Watergate, then Congress passed laws. The campaigns of 1976 were the first ones after the new laws imposed strict limits on contributions to candidates and required disclosure of campaign money. The Federal Election Commission was created to handle candidate reports and to enforce the laws. Congress also created a system of public financing of presidential campaigns. Candidates for president had to raise small dollar donations in order to receive funds from the government, and then agreed to limit the total amount of money they would spend in their campaigns. Every candidate for president in 1976 participated in this public money system, including the two eventual nominees, incumbent President Gerald Ford and the challenger, Jimmy Carter. That year, 1976, my guest graduated from Virginia Law School. Soon thereafter, he came to Washington to become one of the first lawyers in town to call himself an election lawyer. Bob Bauer, from the beginning, was the go-to lawyer for Democratic Party committees, candidates, and office holders. He was campaign counsel to numerous senators and congressmen. He was counsel to several candidates for president, including Barack Obama and Joe Biden. He served as White House counsel under President Obama. Today, he is a professor of law at NYU Law School. Bob wrote a book about his experiences titled The Unraveling. It's part memoir and part essay on how the law and lawyers operate in politics. It also claims that democracy is in crisis. The book was released in June 2024, 2 weeks before the historic debate between President Biden and President Donald Trump. Bob Bauer played the role of Donald Trump in preparing Joe Biden for that debate. We're going to talk about this, hopefully, and many other things. Bob, thank you for being here today.
Thank you, Jan, for having me. Good to see you.
One of the things that I thought we would like to start out with is a little more background about your family and education. I always was impressed, as you know, by the fact that your parents were immigrants to the United States and became citizens. So your father was Austrian, your mother was Czech. One of the reasons that was of interest to me is that we have sort of a shared background, family-wise.
We do, yes.
My father being Polish, my mother being Belgian. I mean, we came from different parts of Europe. Where were you born and where were you raised?
I was born in New York City, but left after 2 years, and my father ended up in Washington, D.C., where he continued government service as a foreign service officer. I spent a good bit of time overseas. I spent several years in Egypt and in Iran and France before I went off to college. He was a lawyer in Austria before he left in 1938 when the Nazis marched into Vienna. He was on the last train to Prague, and it was in Czechoslovakia that he met my mother in flight. And the two of them with her parents ended up fleeing to the United States together via Portugal. And he was very intensely involved in politics. It certainly made an enormous difference to me. It affected me profoundly. That was the dinner table topic most nights, if not every night. And he was also very much interested in, he couldn't become a lawyer in the United States. He couldn't transfer his degree earned in Austria to the United States, but he was very interested in the law and very happy that I chose to go to law school. So I had both an intensely political background, but also a background as the son of someone who very much cherished the legal profession and the practice of law.
I mentioned that you graduated from law school in 1976 at Virginia.
Yes.
Of course, it's near Washington, D.C. Your parents were living there at that time, I assume.
Yes.
Obviously, the whole field of election law, as I stated, sort of got started in 1976. And so you were a graduate from Virginia. What did you immediately do after graduation?
I had always thought of putting my law degree to use in politics. That was always an interest of mine. And little did I know I'd be graduating at the onset of that period, the experiment in regulation that you just described at the outset of the broadcast. But my first step was to learn basic legal skills. And so I ended up in a large law firm in Philadelphia, moved very quickly to its Washington, D.C. office. And then eventually I ended up at the law firm where I spent the better part of 4 decades building a political law practice. And that was a law firm of Perkins Coie, which recently merged with a firm overseas out of London. And it is now known as Ashurst Perkins.
Oh,
But I was not there for that event.
you were with Perkins Coie for a long time, as you say. When did you do the transition from being a lawyer in a law firm to becoming a law professor?
Well, I was always very interested. I started writing law review articles and periodicals on issues in law and politics while I was practicing full time. And I wanted to do more of it as I got older. And so I ended up teaching part time at NYU and then full time beginning 2018, although I took a leave during the presidential campaign in the fall in 2020 and so forth. But I've had that association for now a good number of years.
You've played different roles as a lawyer, as I mentioned, and you had different relationships with politicians as a lawyer. You were sometimes the lawyer for a politician, including President Obama, in his personal capacity. You were his personal attorney. I think the same was true with President Biden and obviously other clients. You did serve in the White House as counsel, White House counsel. So you, in effect, were a government lawyer. And then you did a lot of work in politics representing political campaigns. I mean, you had candidates who were running for office and you're giving them election law advice. Tell me a little bit about how the different roles affected you as a lawyer. I mean, a lawyer has to provide independent counsel to their client and to do so in a way that is not compromised or conflicted with other issues. I remember early on in my career, a senior attorney advising me as a young lawyer, rule number 1 is know who your client is. Confirm who is the client. And then all the rules about lawyering as well as ethics follow from that. What was it like shifting your capacity as a lawyer in these very different contexts, sometimes with the same individual, right?
Yes, well, that was excellent advice that you receive. And I teach a professional responsibility course about lawyering in public life at NYU. And we spend a lot of time discussing the fundamental question of who is your client and to whom do your ethical obligations, to whom are they devoted? Because as you say, the ethical obligations flow from the identification of the client. I think it is fair to say that in one sense, that's a very simple question. In another sense, it's very complicated. So I'm just going to flip quickly to the White House piece, although I can talk a little bit about how this particular issue plays out in private practice. In the White House Counsel, this has been a topic of some significant controversy over many years involving the role of the White House Counsel. The White House Counsel is very close to the president, one floor above, chosen by the president, a member of the senior staff, not subject to Senate confirmation, typically, but not always, with a long history with the president. In my case, and that's not the only case, in both a personal as well as a political capacity. But you are a government lawyer. You're not the president's personal lawyer. You're not the president's campaign lawyer. And it's extraordinarily important when you take that position on. You have to keep remembering, if in fact you ever forget it, that is your obligation, that your obligation is to the president as the president of the United States, an elected official, not to the president of the United States in his or her individual capacity or in some kind of political capacity. And that should be relatively simple to keep in mind. But of course, I just mentioned you're a member of the senior staff. You were at close quarters with the president. You obviously became involved with the president because you share in any number of respects and want to support him in the fulfillment of government objectives. You certainly care whether the president's going to be reelected. And so you have to understand that while you're a member of the senior staff, and if you will, I like to say, wearing the same team jersey as the chief of staff or the deputy chief of staff, at the end of the day, your obligation is to render independent legal advice in the best interests of the presidency as an institution. And that requires a lot of thought in some contexts about, what precisely does that mean? I'll give you one anecdote where the lines are really difficult to discern, and it's a simple but by the way, brings into the name of the current president. You will recall that in President Obama's first term, there was suddenly a flare-up of these groundless questions about where he was born. And the principal author of those misrepresentations, or the one who attracted most visibility for them, was none other than Donald Trump. And the question was, how was the president going to respond, having posted his official birth certificate on the campaign website years before in the course of the 2008 presidential campaign? Well, then there was more and more pressure on the president to, at least from some quarters, not all of them, to supplement the official document with another one, which is called the long-form birth certificate that is in a vault in Honolulu. I should mention there was other evidence the president deduced that didn't seem to matter to his critics. For example, the birth announcement in the Honolulu paper within a day of his birth. Having said all of that, the decision was made to request from the state of Hawaii the birth certificate, was not the official birth certificate, but the so-called long form, which sits in that Hawaii vault, in a government vault. And the decision was made that his personal counsel, even though this was a matter that arose in connection with the performance of official duties and allegedly bears on his eligibility to hold the office, his personal counsel should fly to Honolulu and retrieve the long-term birth certificate. And then it was returned to me in the White House, and I went into the White House press briefing room to distribute the long-term birth certificate to the reporters who were interested in the issue. It's an unusual issue. It's not the one that I think probably best illustrates the kind of confusion or potential overlapping of roles, but it's certainly an interesting one. And indeed, that's what happened. I surrendered my responsibilities as personal counsel to the president when I entered the White House. Another one took on those duties and was the one who flew to Hawaii to retrieve the birth certificate.
And that other lawyer would have been a member of your former firm that you'd left, right?
Yes, indeed. Judy Corley was my partner and took on those responsibilities.
So in your case, you were able to bifurcate your new role as White House counsel from your prior role as a personal attorney as well as campaign attorney to the Obama campaign by transitioning those responsibilities to others in your old firm.
Correct.
Which you had left. That leads me to another question in this context of who's your client and who are you lawyering to. If you're a government attorney and you're the attorney, White House attorney in the White House, your conversations with the president presumably are not conversations with a client. He's not your client in the legal, ethical sense. So my question is, what happens to the attorney-client privilege? Are your conversations with the president as a White House counsel privileged or not? And if they're not privileged, how are they protected, presumably under executive privilege principles or things of that sort? Am I correct?
Yes, you're absolutely correct. There was litigation of precisely the issue and how these privileges apply to lawyers during the Clinton administration, in the course of the various controversies in connection with which he needed both government advice and personal legal advice. I should mention, you often see this displayed quite graphically on the floor of the Senate during his impeachment trial, in the course of which I provided services to the Democratic caucus. You had both government and personal lawyers addressing the United States Senate on behalf of the President of the United States. So that shows again how efforts are made to keep those boundaries to some degree observed. But you're quite right. There are government privileges, executive and other privileges that may apply to communications that the president has with his lawyer in the building, his White House counsel, just as he might claim them with respect to members of the senior official staff, other government employees. On the other hand, if the president is in the middle of worrying about seeking to address an issue that we would characterize as a personal issue and chooses to bring the White House counsel into that conversation, believing that the attorney-client privilege attaches to those communications on personal legal matters, the president would be mistaken. The privilege doesn't attach to that. So something that was in thought has to be given how to organize these conversations with the president that involve lawyers. And a lot of thought is given to those questions. And again, there are overlaps. There are always overlaps. Let's assume, for example, the president, because we've been speaking about lawyering in a personal capacity, lawyering in a political capacity. President runs for re-election.
Mm-hmm.
Again, it's one president, can't divide the president into different pieces. The campaign lawyers advise the president on campaign issues. Some of those issues come to the White House because they involve questions like, for example, how much the campaign needs to reimburse, or the National Committee has to reimburse the president for the cost of using Air Force One on campaign travel. And so at that point, government counsel do become involved, representing the people of the United States in ensuring that official resources are not diverted to a political purpose. But campaign lawyers are also involved, but they're representing the campaign. They're not representing the president. And in fact, I should mention, there's obviously going to be some kind of tension there because campaign counsel are going to be looking to offload, you and I both know this, as many campaign costs as possible to third parties, including the U.S. government, so the campaign can conserve resources, whereas the government lawyer is laser focused on making sure there's no diversion or questionable use of government funding for a campaign-related purpose.
One of the things you mentioned in your book is how large the White House counsel's office is in personnel. I mean, I think you threw out the figure of 25 to 30 lawyers are part of the White House counsel's office. And you discussed some of these complications that you just covered here. I was intrigued by the fact that one of your proposals to simplify things was perhaps to transfer all the lawyering from the White House to the Justice Department. Please let me know exactly, what you had in mind and whether you still have that view. It's been now over 2 years since you wrote that book and have made this proposal. If you transferred so much of this work to the Justice Department, wouldn't it make it even more complicated than what it is now in the White House?
You're quite right. It is not only complicated, but it turns out, and by the way, I was never able really to sell that proposal to many people, and now I can't even sell it to myself. I think it was a bad proposal. Here was what would lay behind it. The intention on the way to hell was a good one. What lay behind it was the criticism that has been prominent, has made it to op-ed pages of major papers, that White House counsels are lackeys. They're just in the building to give the president a yes answer to whatever question the president wants answered in a yes fashion. And they just don't, White House counsels don't conform to the independent professional standards we expect of DOJ attorneys. My thought was the president still needed lawyers at close quarters because there are issues that come up every day in the West Wing. They can't just travel over to the Department of Justice, to that huge institution. So there would be a White House counsel in the building with a couple of deputies, but the bulk of the office would be in a different cultural environment. It would be at the Department of Justice, practicing with other professional DOJ attorneys, and work would be allocated on a priority basis. I mean, they would devote their time to presidential issues, but the environment would be different. They wouldn't all be either in the West Wing or most typically the bulk of them in the old executive office building, the Eisenhower building next door. Even under then conditions, when I floated this suggestion, and then Jack Goldsmith and I put it in our book on presidential authority in 2020 on reconstructing the presidency, I heard all sorts of objections. One objection was, well, if you move all those lawyers to the Department of Justice, they're going to be out of the mainstream of chatter inside the building, and they won't be in a position of knowing their client well enough to pick up on issues on which the client requires counsel, even if the client themselves haven't figured out that they need the counsel. You're moving a source of information. The objection now is even more profound. And the objection now is, in what manner are you going to achieve independence or some kind of independence of spirit by moving them to the Department of Justice? We've learned in this administration, and by the way, the newly confirmed Attorney General said it again just the other day, the Department of Justice has never been formally an independent agency. Now, the norms that typically serve that independence have crumbled away. The president made it very clear he gets to direct the Department of Justice in every respect, including on enforcement decisions that used to be protected by the norm. So what are you accomplishing by taking all these lawyers and being in the Department of Justice? You're not sanitizing them in any way, sort of cleansing them of improper motive in advising the president. So I don't think that proposal flies any longer. I don't know that the current situation with the Department of Justice is going to last from administration to administration into the future, but I don't think the old norms are going to snap back anyway, precisely in the form in which you and I knew them over the course of our career.
Well, that may be one of the ironies of your former proposal, which suggested moving the lawyering from the White House to the Department of Justice, is that the Department of Justice is increasingly recognized as having to be responsive to the president. After all, they're part of the executive branch, and that the president is endowed by the Constitution in executing the laws. So that's part of his responsibility. And the lawyers at the Justice Department had developed this image of some platonic view of independence, largely because of Watergate, which I discussed in the introduction. Watergate not only created this whole body of election law because they decided they were going to regulate politics, but it also, as an ancillary, sort of created other elements to sort of reform the Justice Department. They even created the special counsel law, right? We used to have independent counsels that were supposedly not part of even the Justice Department to investigate certain alleged violations by public officials. And that has all seemed to erode. And maybe it was expedited by Donald Trump in the way he saw the office of president, but it seems to also be a natural erosion from what was a very unnatural view of the Department of Justice caused by the corruption of Watergate.
Yes, although I'm going to say something not in disagreement, but maybe in qualification of what you just said. There was something very healthy, I think indispensable, in the notion that you wanted to maintain at least some distance between the prosecutorial function and political motivation. I think generally speaking, people don't think the vast and really vast prosecutorial apparatus of the federal government should ultimately serve political purposes. Going light on friends of the president and going after enemies of the president. You're quite right. The president's always had the ability to direct those prosecutions. There's nothing constitutionally infirm. There's something morally, politically, ethically infirm, but not constitutionally infirm about that presidential control. And so various efforts were made to build on that norm, to restrict the people in the White House who were entitled to call the Department of Justice, the topics that they were entitled to discuss. There were just practices and procedures that were developed to defend the independence, particularly of the prosecutorial function. That's a complicated topic. I'm not suggesting it's a simple one, because the president certainly does dictate law enforcement policy. But the question is whether or not the president should be identifying the people who should be prosecuted or not be prosecuted when obviously the president's a political figure and the administration has every reason to manage, speaking crudely, the prosecutorial function to serve its broader political purposes. So there was something very valuable and important in that. And that's by the boards now.
Mm-hmm.
It's utterly in this administration. Now, when I say I don't think the norm will completely snap back, the White Houses have always been restive about their the lack of control over independent agencies and the department, because the president is accountable for everything that administration does, every rulemaking its independent agencies produce, every prosecution that its Department of Justice either chooses to take up or doesn't choose to take up. And so it's just as natural for the president to say, look, I'm responsible for all of this, and I need to have visibility and some measure of control. The question becomes, how do you guard against the evils that are inherent in an unrestricted degree of political control? That is going to be a major challenge for the future, but I don't think the very purest view is going to prevail into the future. I think there are going to be modifications of the old norms, but not their complete restoration.
Yeah. Well, and also the Supreme Court has confirmed the principle that has been in doubt for a while, that the president has the authority to a certain degree over independent agencies by recognizing that the president can fire independent agency leaders. And really, there's going to be a political tension substantively, but also over the policies and procedures of an agency. They are affecting laws that have been passed by Congress. Congress wanted them to do something. The president's supposed to follow the orders of Congress. And really, the political dynamic and tension constitutionally is always going to be between president and Congress. Congress is going to say, well, you're being political because you're not doing it the way we intended you to do it. And the president's saying, well, you're political because you told me to do something and I'm doing it, but you now disagree with me on this. It's a very interesting continuing dynamic that I agree is not going to get resolved. I do think that things have changed, not only for the Department of Justice, but also with independent agencies as a result of the Supreme Court decision this most recent term. Now, I assume that the long-form birth certificate was not the most challenging thing you encountered as White House counsel.
No.
And assuming we haven't already touched on it, what would you say was the most challenging issue or development that you had to address as White House counsel?
It's very difficult to put together, a top 5 list, because one of the challenges of the job is that something's coming up all the time. There are issues on the long-term list, and then there are issues on the short-term list, and then there are issues you didn't anticipate that suddenly get thrust onto the list and have to be addressed the same day. I could probably identify issues in each of these categories, subject, of course, to my treating confidentiality and privilege issues here appropriately. Let me mention one thing that was a very significant challenge for me coming in, which is a large share of the portfolio of the White House counsel's job has become advising on national security issues. And I had no experience in national security when I took the job. And I wasn't going to fake it either. There are White House counsel who developed a very passionate interest in those topics, and I certainly found them very engaging. But I also thought it was important for the credibility of the office for me to decide how I was going to manage that piece of the portfolio when it was obvious to anybody, including to myself, that I might be able to study up on a significant issue, but I wasn't an expert on national security. I didn't have vast experience. I relied heavily on staff. I had two excellent deputies for national security work who in turn had other lawyers they could depend on to help them, a deputy for national security affairs and a special counsel for national security matters. And I had regular meetings with them, and there were times when they said, you need to be at this meeting in the fit room, and here's all the background material that you need to master. It was a question about the War Powers Resolution, which was very controversial in 2011 when the United States joined with NATO in an attempt to prevent a massacre in eastern Libya by the then president of the country, Muammar Gaddafi. So I had to figure out how to work that because I wanted to make sure that the president was getting the best possible advice, and I just also needed to preserve the credibility of my office. And that was not for me to spout out on topics that I had not mastered and had no professional career experience with. So I would put that as a very significant challenge for me. But I was very fortunate because I had huge confidence in the people who worked for me. They briefed me well. They prepared me for the circumstances in which I really did need to deliver an opinion to the president directly. I would have to put that at the top of the list of things that I felt needed to be managed, and that is an important part of the White House counsel's duties in modern times.
Confronting national security and intelligence officials is something that came up several years after you left the White House at a time when you were counseling the Biden campaign for the 2020 election. One of the big controversies just before the election was so-called laptop computer of Hunter Biden. In response to that, there were 51 former national security intelligence officials who issued a public statement saying that the alleged laptop really was a hallmark of Russian
Disinformation.
disinformation. Yes.
I don't know if that's a term that they use, but that's, I think, the general idea. Yeah.
What was it like handling that issue as campaign counsel? I assume that was something you had to sort of address during the Biden campaign.
Yes, as counsel of the campaign, not as counsel to Hunter
Oh,
Biden.
I understand, but this pops up. You were White House counsel. You know about national security issues. Suspect you knew several of these signatories to this letter. What was your role, if I may ask, if any? And if so, what was your reaction to this whole episode in that campaign?
First of all, absolutely would have crossed my path in a number of ways, because as a lawyer to the president personally, as well as advising the campaign, although there my focus was primarily on voting rights and election administration issues. Anything in the environment that would affect public opinion, potentially affect the course of the president's reelection effort and whatever, would certainly be of concern to me. I do not have right now a clear recollection of the text of that letter. Certainly some of the signatories were distinguished people in the field, and I think they were issuing a cautionary note that in the heated 24-hour news cycle and with well-documented Russian interference in our elections and other foreign government interference in our elections, there was a reason to take a step back and not credit everything that might appear, particularly in publications hostile to Donald Trump, hostile to Joe Biden. But I don't have any view of what informed the judgment in that letter on the part of each and every one of those signatories. I just don't have any recollection of that. And that would not have been something that I would have shepherded or been responsible for as a lawyer to the president personally, or in my capacity of advising the campaign in the areas in which I advised it.
Well, I asked in part because your book does sort of end with the Biden 2024 campaign, and with respect to your observations in the book about the 2020 campaign, there was no mention of that controversy with Hunter Biden. There's a lot of stuff here that I don't think you've actually addressed publicly before. That's why I'm raising that question, having read your book, by the way. So if I could continue to raise some issues that don't seem to be addressed in your book, in your representation of President Biden, both his personal and campaign capacities, you were his counsel when there was the investigation by Robert Hur, the special counsel, regarding the possession of classified documents after he had left office. What was that like? You were in the room, as John Bolton would like to say this, in retrospect now, particularly because everyone has more information, can look back at least a couple of years. Lots of events transpired afterwards that would reflect on the investigation and also the comments from the special counsel. How would you describe that experience now, and what thoughts do you have about viewing that whole controversy today?
I'll start by saying, obviously, what I say on these topics is constrained by just the privileges that we discussed earlier. I mean, there are certain things that I can't discuss, both in the infidelity of the attorney-client privilege and out of respect for broader confidentiality obligations that lawyers obviously have toward their clients. I will say I have written about one piece of it, and that is what her investigation and other special or independent counsel investigations, what they tell us about the experience of attempting to create this independent space for law enforcement divorced from Department of Justice control. Now, you mentioned the independent counsel statute. Of course, that was a law that, among other things, brought the judiciary into the process of, on recommendation or request from the Attorney General, actually appointing and supervising the independent counsel who was charged with investigating any allegations of wrongdoing against senior executive branch officials. Both parties were exhausted by that law by the time it came up for, I think, another round of renewals, and they let it die because the view was, and this was something famously and presciently predicted by Justice Scalia in a dissent to the Supreme Court's decision upholding the constitutionality of that statute, there were just too many points of political controversy that plagued that statute, and both sides ultimately suffered from it. Both sides tried to exploit it to attack their political adversaries, or maybe in good conscience to both attack, but also because they thought there were substantial grounds for criminal investigation, and both sides suffered from that. And so by polite bipartisan agreement, it was allowed to die. It was replaced, however, by regulations, Department of Justice regulations, that provide for the appointment of a special counsel. The judiciary has no role in the appointment of that special counsel. That's an appointment by the Attorney General of the United States. Mm-hmm. And again, it's meant to afford, and we could talk about the specifics if you want, the counsel so appointed a significant measure of independence, not total independence, ultimately supervised by the Attorney General, and ultimately all the final calls of the Attorney General is to make, but nonetheless a significant measure of independence in conducting politically sensitive investigations.
So the Robert Hur situation was that he was appointed by the Attorney General, Merrick Garland.
Correct.
His mandate was take a look at this, investigate it.
Yes.
He then had the obligation to make a report to the Attorney General. If there were any sort of prosecution, would it not have to be the decision of the Attorney General?
Yes.
All right. So there is no independence in the sense of making a decision on whether to prosecute. It's a very limited prosecutorial mandate, although it's necessarily intrusive and potentially political.
I should just mention, under the regulation, the Attorney General, for whatever it's worth, has to accord the special counsel significant deference, weight to his decisions, or her decisions, but the decision ultimately does rest with the Attorney General if the Attorney General chooses to disagree with the conclusions of the special counsel. There's also, I should add, a built-in alleged check against an attempt to control the special counsel in untoward ways, and those are various congressional notification procedures that have Congress aware of what's taking place in the management of the investigation. And my only point, just to clarify it, is I was always a skeptic of how the independent counsel statute operated. I've been a skeptic, although I thought it was reparable, of the way the special counsel regulations operate. And now I don't think that this experiment succeeded at all. We had an independent counsel, we had a special counsel. There have been proposals, including ones that I've made, for amending the special counsel regulations. But I think at the end of the day, this particular effort to create a mechanism for independence has been unsuccessful. And I think that was also, to bring it back to the question you asked in the first instance, I think that was something that was brought home to me, reinforced. That conclusion was reinforced by my experience with the Biden special counsel investigation. And I'm quick to say, let me just say, that is not an attack, a personal attack on Robert Hur or Robert Hur's deputy. I'm speaking just as a general institutional matter. I think the pressures, incentives, and disincentives that operate within that sphere ultimately doom that experiment, and they doom that enterprise. It doesn't work.
Well, I suspect that President Trump will agree with you wholeheartedly, especially after his experience in the Robert Mueller special counsel investigation in his first term. I think one of the aspects of the Hur investigation that is the arguably most controversial was not his conclusion that there shouldn't be a prosecution of President Biden, but his explanation as to why there should not be a prosecution, which was that he was a nice old man who seemed not to remember things, which of course got publicized extraordinarily widely. You're on record as saying that that was untoward, was unnecessary to his report. But in light of what happened afterwards, and of course you 4 or 5 months later were prepping the president for his debate with Donald Trump, the president's mental state and his cognitive abilities, if anything, were quite amplified as a result of the debate. Are you at liberty to sort of share with us any observations you had about the president's cognitive abilities in the time that you were representing him?
The president underwent a 5-hour interview with Robert Hur in the middle of the crisis in the Middle East that was precipitated by the October 7th Hamas attack. And the transcript of that interview was released. I think the president, over the course of that interview, demonstrated he was perfectly capable of taking and answering questions effectively in the context that I was responsible for, or the circumstances in which I had significant responsibility. And I will say also that my quarrel with the report, and by the way, the president's age and whatever were not the only reasons, in my view, that Robert Hur ultimately concluded that a prosecution would not be warranted or would not be appropriate or shouldn't be pursued. There were other reasons, and I think there were reasons well grounded in the law that governed the kind of documents that were at issue in the Biden case. I was surprised, frankly, that the investigation went on for 15 months because I thought it could have been wrapped up earlier because I didn't think there was a plausible case for prosecution. But there are rules, and this was a flashpoint, a huge flashpoint in the independent counsel statute, which is the production of lengthy reports by independent counsels that frequently included commentary about third parties and just the kinds of things that, by and large, prosecutors should not, in an ethical matter, are barred from or limited from making when they decline prosecutions. And we could talk about that if you'd like in some greater detail. This commentary struck me as inconsistent with the kind of limited report that focused on the grounds for declination of a prosecution that I thought the regulations called for. And we made that case in an extended letter with citations to the Department of Justice. The Department of Justice did not intervene and seek to, for example, excise that material from the independent counsel's report. Okay, so be it. That's behind us.
Mm-hmm.
But I think that it is fair to say that in the context in which those reports are prepared, and given the background of concerns with those kinds of what I believe extraneous comments based on a 5-hour interview, I think that was a legitimate concern for me to have as a lawyer, and I expressed it as a lawyer, and we expressed it in the normal process by way of a letter to the Attorney General, who had ongoing supervision of the investigation. But obviously, the department did not agree with us about that.
Well, I don't want to push this point further. I think many people, commentators who have reviewed the transcript and have made determinations that the president was not as sharp as a tack in his 5-hour interview and seemed to have some, at least memory losses and interjecting things about his son and so forth. I was asking you not only because you were the attorney for Joe Biden, but you observed Joe Biden for a long time, during 8 years of his vice presidency and then as his counsel and private attorney. So, I mean, we're talking about 16 years. And then you were part of the debate preparation team, and we know what happened in the debate. A lot of people would want to ask you, Bob, did you notice anything downhill? I mean, I know that people asked all kinds of staffers who had surrounded Joe Biden, about, why is it that you didn't do something? Because he did seem to be deteriorating so visibly over a certain period of time.
First of all, let me begin by disputing your characterization of the transcript. If you go back and take a look at the press reports, you will see that once the transcript was released, there were a number of people who said, I don't read this transcript and find it evidence of some apparent inability of the president to handle that interview. So you'll find that in writing. Now, obviously, people may have looked back after the Atlanta debate and read something different into the transcript than they did at the time that it was released. But I encourage you to take a look back, because there was a systematic attack and a demand for the transcript to be released. And when it was released,
I understand. I'm just
let me finish what I was going to say.
I'm just
The reaction was
quoting what other people say, that not me.
Okay, but I'm referring to what other people said. If you take a look at the press reports on the transcript, that's at least some of what you will see in the immediate response to the text once it was available. Could say more, I won't.
I understand.
Because I don't think it's appropriate for me to get involved in this conversation as his lawyer. But I think that I've said enough about my view of his performance in that interview. And I suppose that's all I need to say, because people are going to have their views. They're going to have their views. And if they base it on that Atlanta moment, that's obviously not a position they're going to take that I'm going to be in a position to dissuade them from.
Yeah. Well, I thank you for just responding.
Sure,
and
of course.
I appreciate that very much. So let me just turn to what I think will be the last topic here, because we're running out of time, and we can go on for a long, long time, which is the Supreme Court. A lot of observations and commentary about the Supreme Court, what it's like, what it's doing, whether it should be changed. Of course, you have Democratic candidates for the Democratic Socialist Party saying that the court ought to be revised or eliminated. I don't know. They want to eliminate all kinds of parts of the Constitution. And this was obviously a topic that came up during the Biden administration to review the Supreme Court. And you were the co-chair of a commission by President Biden to sort of study the topic of what can or should be done about the Supreme Court. What was your mandate on that commission? How would you characterize the outcome in terms of 2 or 3 issues that were addressed, and what, if any, conclusions were drawn?
The president wanted to be a bipartisan commission, and it was. He understood perfectly well that there were certain issues that were just going to provoke disagreement, ultimately up for him to resolve. But what he wanted was a critical evaluation, and that's how it was put, a critical assessment of the court's role over the span of our history, and of reform proposals, a critical evaluation of proposals to reform the court, which would include, of course, what supporters call court expansion, what criticals call court packing, term limits, any number of other reforms, including ones that go to the way the court polices the ethics of its members on conflict of interest issues. And so it's a very lengthy report. It's a very thoughtful report. It was the analysis as a whole was with 3 commissioners offering additional views submitted to the president on a unanimous consent basis. Everyone thought it fairly reflected a balanced assessment, a balanced critical evaluation of the kind that we were asked to provide. I was very, very pleased to work with these people, scholars, some of them active observers of the court, some of them pure academics. And I thought that it made a significant contribution to understanding of those issues, and I see it cited from time to time for that purpose. But it was never going to resolve the current deep disagreements about how the court is performed or the role of the court in American society and politics and culture. But I think that it illuminated some of these issues, and I encourage people to read it, because it's not a dates and battles report. There's some really deep analysis, and in some cases on constitutional issues, and agreement on what the constitutional position, the best constitutional view of a particular issue would be.
Mm-hmm. One of the issues is whether to change the life tenure of justices and to impose some sort of term limits.
Yes.
What did your commission say about that? What were the pros and the cons? And for those who advocated term limits, how would that come about?
The chapter itself reflects the arguments for and against. It also contains a very, very interesting piece about how the transition from the current life tenure position to a term limits regime would actually be achieved. How would that happen? How would you move from the court in the prior regime to the one in which term limits applied? And very detailed analysis of what would have to happen to make that work. So I think it's actually a significant contribution. But again, that chapter reflects disagreements. There are those who think that we're the only democracy in the world that has neither term limits nor a mandatory age limit for justices who serve in the apex court. There are others who believe that it is a mistake and that actually it won't end politics around the court. It will actually, because of the way judicial appointments would take place on a term limited basis, it would simply escalate or cause to be more frequent political conflicts around the court.
Mm.
And those are fundamental disagreements. I happen, for a long time, even before I got on the commission, I happen to think I do not support court packing or court expansion. I do support term limits. And I happen to feel very strongly that that is the right outcome. But there are those and really, really smart, thoughtful people elsewhere and on the commission who disagree. But eventually, I believe, I can't predict this with any confidence at all, but I don't think in my lifetime, but sometime over the next, my children, my grandchildren, I think this issue is going to be confronted directly and probably resolved in favor of limiting terms on the court.
And how, as a legal or constitutional matter, do you change the term for a justice to a fixed term? How does that, legislatively, or do we have to have a constitutional amendment, or do we have to have a revolution to do that?
Well, I don't think we have to go to the streets to do it. I don't think any blood needs to be shed. But I think that there are proposals for accomplishing this through a statute. And I won't delve into the details of that. And then there's a view which I share that a change so monumental really cannot be made and cannot hope to attract the public support it needs without a constitutional amendment. I also reject the view that I often hear, well, we'll never amend the Constitution. I don't think that's true. We don't amend it frequently, and we can have a very robust debate about whether the barriers set by the Constitution for amendment are too high. That's fair. But I don't agree that a constitutional amendment program, a pursuit of a constitutional amendment to accomplish term limits is somehow delusional and somehow it can't be done. I disagree with that.
Bob, you've had a very distinguished career. It's kind of unusual, not only for its longevity, but also for being concentrated in an area that is of great interest to the lawyers of the country, but also increasingly, as my observation is, that young lawyers, increasingly they come up to me and say, boy, I really like being an election lawyer, a political lawyer, all these things that are so interesting. And by the way, read about your clients in the news and the things that are done. It's very public. What advice would you have for a law student or young lawyer who says, boy, this is something I want to do?
Here's my advice in 3 simple parts. First of all, you don't have to specialize in election law or campaign finance law to be a lawyer who's active and influential in politics. So if you're interested in law and politics, the answer isn't necessarily to slip into that particular niche. You might want to, but that's not the only answer to being an effective lawyer in politics. My second piece of advice is when you come out of law school, I think the first order of business is to take on whatever responsibilities in your early career will help you sharpen your legal skills. So I would worry less about subject matter expertise than becoming, through training, the best possible lawyer you can be. And then the third point I would make, and I'd be interested in your views on this, when you and I were practicing early on, campaign finance regulation was this robust field. Well, less so now, for a whole host of reasons that would probably command an entire podcast. It certainly includes the constitutional environment that has restricted congressional restriction of campaign finance activities, any number of reasons why it's not the field that you and I practiced in, at least in part, as among our other items in the portfolio of being an election lawyer. And so people need to keep their eye on where the law is going before they conclude that it's enough to support a private practice in the future.
Right.
Right now, if I'm not mistaken, and correct me, the Federal Election Commission doesn't even have a quorum. They can't act. And do you hear anybody complaining about it?
No, and I think people's attention is moving on, and of course the area is changing. It's one of the things that we've observed as practitioners, you and I, that what's important and what the demands are for lawyers who are involved in the political process are changing. They're actually getting more interesting and more complicated and burdensome. And I think it's important, in the interest of full disclosure for our listeners, to let them know that you and I have known each other during this whole period of time.
Yes.
In fact, we met in person for the first time in the Supreme Court, arguing on opposite sides of an issue on a case, and that would have been in 1981, in the October 81 term. And I think it's a reflection of both the experiences that we've had, the longevity we've had, but also that it's possible for lawyers and politicians who are on different sides of the aisle to actually work together and develop a relationship that is long-lasting and meaningful. And I very much thank you for coming on this program and sharing with us your thoughts and experiences as you have done. Thank you, Bob.
It's a pleasure. Good to talk to you, Jan. Thank you very much.
And I also want to thank our sponsor, the Holtzman Vogel Law Firm. Any opinions that are expressed here are those of the hosts and our guests and don't necessarily reflect the views of our sponsor or their clients. All of our episodes, by the way, are available on Buzzsprout as well as other platforms such as Spotify and the National Law Review. Thank you all for listening, and I hope you will join us on the next edition of Early Returns. Have a good day.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.